She wasn't pleased last night.
Oh,
They
well,
just went to sleep.
what happened last night?
Nothing that we did.
I
don't
think it's because when someone would say,
Can you hear?
"Can you hear?"
She
and they
gets-
would look at her. I mean, that's kind of calling her out, you know.
Right.
So, but she was not happy about that.
She seemed to, every time anybody mentioned about being able to hear, the look was not happy.
You almost got elected vice chair last night without being here. We want you to think about it.
I've already been.
Well, I was talking to her.
Did
about
you?
it, but
Okay.
yeah, you know what? If nobody, and I get it.
I'm too new. I don't even know
She's
what
too
half the
new,
words mean
Yeah.
Girls
yet.
too new. I know Mark's not interested.
Yeah.
I'll do it if, I get it. He's got all these surgeries ahead
Yeah.
of him, so.
So I have one hopefully tomorrow. They sent me the updated reminder with no time
No
for
updates.
surgery. And then when they collect this, whenever they fix that, I don't know.
Okay.
Surgery procedures, reminders, with no reminders.
Good evening. Want to go ahead and welcome everyone to this quasi-judicial, thank you, judicial procedure training tonight on Wednesday, April 12th, 13th. I need a lot of help right now. Sorry, I'm still stuck on 85 if you're watching in my head. Want to welcome Bob Hornick. To do our training tonight. We do have, I do want to go ahead and make sure we have a quorum. If I can get a roll call.
Catherine Drum.
Jade Biddle.
Dale Udi.
Ryan Nelms. So we do have a quorum, so we are good to proceed. And open it up to you.
Well, I'm happy to be here this evening, and hopefully you'll find this to be educational for you. Our
Mr. Warren, do you mind, just pull that up a little, or the one right
Or the
behind
right-
the computer might be easier.
and
That way we
I
get you on the
will
recording.
That's perfect,
Try to make it so that everyone can hear me.
perfect.
I don't usually have a problem with that, so. So I'm with the Bro Law Firm in Chapel Hill, and just to give you just a brief background, we represent 20 to 25 different towns around the state. So municipal law and providing guidance to different councils and different boards on quasi-judicial hearings and the like is what we do primarily. So I'll get you started very quickly. I'm not going to read through all of the slides on the PowerPoint, but we'll use them as guidance, and you'll find them useful, I think, if you need to in future times when you have questions about some quasi-judicial procedure or the like. The first thing I want to talk about is kind of distinguishing between the different kinds of powers that local governments have. Legislative authority, that's what your elected officials do. They adopt ordinances and adopt policy for the town. Administrative, that's kind of what your staff does. Issues zoning compliance permits, building permits, reviews those kinds of applications for which there's really no discretion to be exercised. Advisory powers, typically your planning board. I don't know if I'm sure with respect to zoning amendments and the like, the planning board has to make recommendations. They're providing advice to the decision-making board. And then there's the reason we're here tonight, quasi-judicial hearings. Typically, quasi-judicial hearings or decisions arise from issues in your land development ordinances. Variances are quasi-judicial decisions. Special use permits are quasi-judicial. Hearing appeals from the zoning administrator's determinations are quasi-judicial matters. And what that really means is that they're kind of like court proceedings, kind of like courtroom light, if you will, where rules of procedure, due process, rules of evidence to some extent are all applicable. And the idea is to make sure that the applicant or the appellant in the case, as well as members of the public or those who might be opposed to the application, all get a fair shot. That's really the fundamental behind quasi-judicial process. A variance, you may already know this, and if I'm being too elemental about it, just let me know because I don't want to bore you with it. But a variance application is really called for or authorized by your zoning ordinance and by the general statutes. It allows the Board of Adjustment to give relief from the strict requirements of the zoning ordinance or the land development ordinance of the LDO. Now, in North Carolina, you can give relief from dimensional requirements, height, side yard setbacks, front yard setbacks, and the like. You cannot give relief from the use requirements of the ordinance, so that you can't say in a residential district that you're allowed to use the property for a manufacturing purpose. So that's one of the distinctions that you have to be careful of with granting variances. Special use permits. Special use permits are authorized by the law, and in Landis, the Board of Adjustment can approve special use permits. Generally speaking, those involve uses that are permitted by the LDO, but only if certain findings are made. Typically, they're uses that might have some impacts on adjoining or nearby properties unless certain circumstances exist or do not exist. So in that case, you have an applicant, they submit their application for the special use permit, they have to make certain showings, and the board has to make certain findings based on the evidence that is produced at the hearing before a decision can be made on a special use permit application. What the law has said about special uses basically is that the legislative body has already, your elected officials, have already decided that the use is okay in that district, again, if certain circumstances exist, if certain findings can be made with respect to that use. This slide has to do with, what is the Board of Adjustment's authority and what limits the Board of Adjustment's authority? The Board of Adjustment is authorized by the general statutes. We're now under Chapter 160D. I mean, that was a huge change. At least people thought it was a huge change to go from 160A to 160D with respect to land use decisions. From my perspective, it wasn't so much of a huge change in the law, but what it did is creation of Chapter 160D by the state legislature kind of brought all the land use stuff out of 160A and moved it to 160D and tried to make the rules pretty much uniform throughout the state. Back before Chapter 160D was enacted, there was a lot more variety of the nomenclature that was used for zoning decisions, and I think that caused confusion. Conditional use permits were called special use permits some places and not other places. There are variance requests, there are special exceptions. All the different nomenclature got to be very confusing. So really the land use bar, the attorneys who practice a lot of land use law, got together and spent a lot of time trying to figure out how to codify it and hopefully to make it a little bit less confusing for the practitioners. Also, whereas counties were governed by Chapter 153A and towns are governed by Chapter 160A, all of the land use stuff, both for counties and for towns, is now found in Chapter 160D. So I don't think there's really much of a substantive change in the law, but Chapter 160D really just put all the land use regulations together in one place. The most important takeaway from this slide is anything that is brought before the Board of Adjustment under the Land Development Ordinance is a quasi-judicial matter. And therefore, whenever the Board of Adjustment hears an appeal, hears a request for a variance, hears an application for a special use permit, you have to follow quasi-judicial procedures. And let me go back to that last point. So you have Chapter 160D, you have your land development ordinance regulations. The board probably has rules of procedure, and if you don't, you should. The last bullet point there, your own common sense and experience are also important. I mean, some people forget that you really, just use your common sense, and you usually will be, keep yourself out of trouble. On this slide, different jurisdictions have and exercise different degrees of formality about their quasi-judicial proceedings. Some jurisdictions, some of the bigger cities in particular, it's really much more like a courtroom, where you have your board sitting up on the dais, you have your petitioners or applicants or appellants, you have your opponents, kind of like a plaintiff and a defendant in a lawsuit, where rules of evidence and rules of procedure are very, very strictly enforced. Now, there are certain rules that need to be strictly enforced, but different jurisdictions have different degrees of formality. It's really a matter of choice among the board members about how formal they want to be. Our second bullet point, the rules of evidence don't strictly apply. I mean, they apply kinda, but hearsay may be admissible in a quasi-judicial proceeding, whereas in a courtroom, hearsay is not supposed to be admissible, although there are more exceptions to the hearsay rule than there really is the hearsay rule. The most important thing with a quasi-judicial hearing in this regard is that board members are supposed to make their decisions on quasi-judicial applications based only on the information and testimony that's presented at the public hearing. So that if you learn about a situation outside the context of the hearing, or if someone approaches you and wants you to talk to you about a matter that's going to be brought before you at the hearing, you really shouldn't be talking to anyone outside the context of the hearing about the subject matter at the hearing. And that I find to be perhaps the most common problem that boards run into, is that your neighbor or someone, your cousin who lives next door to the site where the application is, wants to talk to you about it before the hearing. You have to discourage that. And we'll talk about this a little bit later. If you do get contact, what's called an ex parte communication, you have to disclose it at the outset of the hearing, put it on the record so that nobody is surprised or prejudiced by it.
Can I ask a question? Is that
Sure.
appropriate?
Let me, if anyone has any questions, if I'm going too fast, there's a lot of material a lot of ground to cover, slow me down, ask the question. I'd rather have a dialogue about it than a
So,
lecture.
in our circumstances, does the public know that we're having this so that would happen?
Well, there are notice requirements.
Okay.
So that with respect to, say, a variance application or a special use permit application, your LDO and the general statutes tell you that at least the adjoining property owners have to
They
be
do.
notified. And in some jurisdictions, it's much more than that. We have some jurisdictions that notify by mail anyone who owns a piece of property within 500 feet, and in some circumstances, even more of the site of the application. But state law and your ordinance require that at least the adjoining property owners be notified at least 10 days in advance of the hearing that the hearing is going to be conducted. And that's to give them an opportunity to be organized if they want to present any kind of information in opposition to or in support of the application. So there is a notice requirement. You have your board chairperson, and the chair really kind of runs the meeting. Doesn't give him any special voting power, but the chair is often asked to make certain decisions about admissibility of evidence, for example, about procedures. If this gets kind of into more of the judicial part of it, there may be motions to disregard evidence or to take a break. The chair rules on that. If there are objections, then the rest of the board can override the chair in certain circumstances. But generally speaking, the chair runs the meeting. One of the I was in a hearing last night, for example, that went for 4.5 hours, okay? I mean, 90 some odd people spoke at the hearing. And fortunately, we had established a 3-minute rule where we said anyone who wants to speak on this application other than the applicant has 3 minutes to say their piece. And those kinds of reasonable rules, practical rules, are advisable. They're not written out in any code anywhere. They're not written in your LDO. They're not in state law. They might be in your rules of procedure, but even if they're not in your rules of procedure, if you know that you're going to have a relatively heavily contested application, it's a good idea to, whether it's through your counsel, your attorneys, or the chair of the board, to talk to the parties involved to say beforehand, here's what our rules are going to be. The applicant needs to be given sufficient time to present a complete application. So you cannot say to an applicant, or you can't usually say to an applicant anyway, you only got 3 minutes to make your presentation. I mean, the applicant has a burden of proof on the application. They've got to be given an opportunity to present their case so they can at least have a chance to meet the burden of proof. If there are organized opponents to the application, usually you give the opponents a little bit more time to make their defense, if you will, to put up their opposition. One of the things that, and then you just may have members of the public who are interested in the application, who feel as if they have some information that might be helpful to the board in making its decision, whether it's in support of the application or in opposition to the application. The public generally is the body or are the people to whom time limits apply. Because, Johnny Jones, who lives 1.5 miles from where the site of the application is, may know about the traffic along Main Street and may have an opinion or be able to provide some factual testimony about the effect of the application on traffic, or they just may say, we just don't like the application. They don't really need more than a minute or 2 or 3 to say their piece. So it's fair game to have a rule, for example, where non-parties only have 3 minutes or 5 minutes per person to say their piece. It's also fair for the board chair to say, if someone has already said what you wanted to say, please don't repeat it. Just say, I agree with what Johnny Jones said. And that's a way to kind of move the application process along. And that's fair and that's legal to do that. Again, the most important aspect being to make sure the applicant has an opportunity to meet the burden of proof, and that the opposition has an opportunity to present information, facts to the board, or expert testimony, if necessary, to the board to oppose the application.
So, can we align with public comments on the whatever time limit they get?
Sure.
That's 3 minutes, right? Or is that 2?
That's right.
So I'd like to align that
Okay.
going into this.
So then so how do we need to do that? We need to make an official notice of that to the
Well-
people involved in the hearing.
What I would recommend, I suppose, is that we establish some kind of, it doesn't have to be a hard and fast rule, okay? But if you think that the applicant only needs 20 minutes or 30 minutes to present their case, I would say before the hearing starts, talk to the applicant, maybe even a few days in advance of the hearing. Talk to the applicant. If you know there's going to be someone there who's opposed to the application, talk to them. Tell them, here's what we think should be the ground rules going in beforehand, so that they know kind of what the limitations are. Now, we usually have everyone's got their smartphone, so everybody can keep track of how much time they have. But you set a timer for 20 minutes or 30 minutes. Like last night, some people spoke for 3.5 minutes. If they've got an extra 30 words to say, and then they're done. It's not doesn't have to be a solid 3 minutes and bam, you're done. But if you need 3 minutes and 2 seconds, you give them 3 minutes and 2 seconds. But that kind of, the limitation kind of on the general public, I don't think you have to worry about that, sending that out in your notice. But I do think at the outset of the hearing, you should establish those as the rules.
Okay.
To kind of create the expectation or to squelch any unrealistic expectation of how that will be handled. If you have people who, we've run into this before, and this is a matter that is kind of up to the board, where people want to cede their time to someone else, so that you can let that happen if you think it will help to make the proceedings more orderly. So you have to think about that a little bit. Now, you might have someone who's opposed to the application, who's not part of this, any kind of organized defense, right, or opposition, but who has 3 or 4 points to cover, and there might be an opportunity for a group of neighbors, for example, to say, we want John Jones to speak on our behalf. Can you give him our 3 minutes too? So that he might have 9 or 10 minutes rather than just his 3 minutes. And that's, a call that you have the authority to make. And I'll tell you, I've represented opposition groups as well. Allowing the opposition to be somewhat organized really helps to move things along. A lot of times you'll have groups where you have 3 or 4 people, each of whom will speak about one particular aspect of the application. Concerns about impact on property value. You might have one person speak about that. Traffic impacts might be another. Stormwater impacts might be another. Each person having their own area of specialty or area of interest, if you will. That also helps the process to be less helter-skelter. And I think creates a better record, because you have to remember that whatever decision you make might be reviewed by a court someday. So having an organized and as clear as possible record would be really beneficial.
Could we set a limit on how many times someone can hit succeeded minutes? Like no more than 3 people can succeed their minutes, or
Yes.
Okay, cool.
Yeah, again, there's no statutory, there's no law about that. It's got to be reasonable limitations.
Right. I just want to make sure I'm being reasonable as I'm thinking through this too. And I think it's safe to say too, until we know what the case is, I don't want to set a limit on the applicant or anyone opposed to it until I at least know.
We have to know what.
Yeah.
Before we can.
Let me tell you, you'll get your application, your agenda packet. It's okay for you guys to look at the agenda packet before the hearing and get an idea about what the hearing is about.
Right.
And
I'm
that,
gonna get those tomorrow.
Okay.
and that may help you to think about, okay, here's what it looks like the issues are, and help you to organize how you think the presentation ought to go. I mean, obviously the applicant and any opposition, they have the right to say their piece, but you have the right to say the manner in which, or the order in which they'll do it.
Yeah, I just want to make sure they have a fair amount of time for the case, if that makes sense.
Right. And that's exactly,
Okay.
I mean, that's, in a quasi-judicial hearing, that's what you want to do, is give everybody a fair shot. In the end, that's what the rules are all about.
Okay.
Excuse me, to that end, if, once we know tonight, like, would we be able to continue to discuss, since we're still in a meeting ourselves, to determine, like, oh, I think we should give them a half hour? Or, you say, once we have some idea, not to discuss the case, but just that, oh, maybe they need,
The
Well,
logistics of the meeting,
Yeah.
basically.
yeah.
I think that the chair can ask each of the members
Okay.
what they think. I don't think you should have a meeting about it.
Okay, yeah, well, I see what you're saying, yeah.
And if you're going to do it by email, don't do it by a group email.
Do it individually?
Do it individually,
Okay, so then it's not
because
an
there are rules
actual
about
meeting.
e-meetings. I mean.
Yeah, that's why I asked
Yeah.
if we could
Yeah.
even talk about it tonight.
That would be my suggestion, is to do it, through, kind
Separate
of on this,
email or, okay.
poll your board members about what they
Gotcha.
think. They can offer you
Okay.
their suggestions, and then you can make that call.
Okay.
Those will be one of our questions, so thank you.
This is a very kind of basic slide, talking a little bit more about what the chair's role is. I mentioned this a little while ago. Motions can be made, and the chair has to make decisions about the motion. The chair should, those are motions, those are different kinds of motions. Like for a motion to approve the application, or a motion to continue the hearing. If you make a motion, the chair ought to repeat the motion so that the public can hear it, and so all the board members understand what the motion is. I've been involved in meetings before that got a little bit discombobulated, and people really weren't sure once in a while what was that motion that was just made, and what was I voting for? How do you remedy that? You take a little bit of time so that the chair hears the motion, make sure the chair understands the motion. Then you can repeat the motion so that your board members and the public who are out here watching and listening understand what the motion is, and it helps to, again, keep the record very clear.
Do I vote?
Under your rules of procedure, I would assume you vote.
Okay, I'm just making
Yeah.
sure. Yeah, I have a vote in that.
Yeah. Typically, the chair is just like a regular member.
Yeah, okay.
Now, in legislative bodies, it's different sometimes, where the mayor doesn't vote except to break ties. But with boards of adjustment, typically, the chairman of the board of adjustment votes. And I didn't see anything to LDO that told me otherwise.
Yeah, I think that's what gets me confused. The mayor doesn't vote, and yeah.
Yeah, and this last bullet point about the chair summarizing the evidence, this is the kind of when you get down to making your findings that are required either for a special use permit or for a variance. We'll talk about those specific findings in a few minutes. It's a good idea for, as the board is making its decision, and if you're making a motion to approve each of the findings or to make each of the findings, to discuss the evidence that's in the record that supports the motion about to make that finding. Again, for the sake of clarity of the record, so that everyone understands what the decision is, what the basis for the decision is, and so that a judge somewhere down the line might be able to understand why you decided what you decided. So one of the ways to do that is to have the chair kind of restate the basis for making each finding and restate what the motion is before you vote on it. Next, we're talking about the responsibilities of the entire board. One of the, probably the biggest overriding factor or concern here is to make sure that going into the hearing, that all of the decision makers have an open mind. That is, it's okay if you have kind of an idea of how whether you think the application is a good thing or a bad thing. It's all right to have opinions, but you have to have an open mind as you susceptible to change if the evidence supports changing your mind. If you go into a hearing, a quasi-judicial hearing, and your mind is set that you are either for this come hell or high water or against it, the applicant or the opposition is not getting a fair hearing. So it is critical to the quasi-judicial process that the board members, the decision members, feel as if they can be impartial, unbiased decision makers, that they can apply the requirements and the standards and the ordinance to the facts that are presented fairly and without prejudice. You shouldn't, as a board member, this is the second bullet point, board members tend to do this sometimes in some jurisdictions. They get the application a week ahead of time. They're reviewing the application. They say, I'm going to take a drive through the neighborhood and see exactly what's going on there. Rule number 1 is don't do that, okay? Rule number 2 is if you do it, you have to disclose it at the outset of the hearing. The reason for that is your decision is supposed to be based on the evidence presented at the hearing. And again, having the application booklet, the packet before the hearing, that's okay because that's going to be introduced into evidence at the hearing. And people are going to be referring to it during the course of the hearing. It's okay to read that stuff and to be prepared as you go into the hearing. But it's a bad idea to go and look at the site and look at the neighborhood and get that, gather that own information for yourself. I mean, if you live half a mile away and you drive past the property all the time, that's kind of part of the baggage that we all bring to a hearing anyway. It's kind of the common sense approach and information. But don't go about, investigating. I'm going to go on the DOT website and see how many accidents there have been at this intersection in the last 2 years. That's a no-no. You shouldn't be doing that.
I think on that same point, sorry, you might get to this in the next bullet, so I might be quiet for a second.
Go
But
ahead.
let's say, talking about don't drive through the neighborhood or the space it is, let's say I live on Main Street down here on this block, right?
Mm-hmm.
The person applying for the appeal lives on the back side of my block. Is that like a conflict of interest or anything?
Well, conflicts of interest, a legal conflict of interest occurs when you, as a decision maker, have a direct financial
Okay.
stake in the outcome of the application. Okay, whether it's either you do, or a family member does, a close family member, or some business associate of yours.
Okay.
The mere fact that the site of the application is 3 blocks away and you know it pretty well doesn't create a conflict of interest, not a legal conflict of interest for you. Now, if because of that situation you feel like you can't make an impartial, fair, and unbiased decision, that's a different matter. And in that case, you might, I call it kind of if the hair on the back of your neck stands up and you feel something's not right, it might not be right.
Okay.
And in that case, what you do is you bring that up at the outset of the hearing, say, gee, I know John Jones because we were at the high school together. He lives 3 blocks away. Man, I just don't feel like I can be fair. I mean, you bring that up and you get excused from participating in the hearing.
Okay.
But, especially in smaller towns, I mean, it's almost inevitable that some member of the board is going to know one of the applicants, is going to know where the property is going to know something about what's going on. You just can't avoid that. And the law recognizes that. So as a practical matter, that's why, the rule is unless you have a financial stake in the outcome of the application, then you don't have a legal conflict of interest.
Okay.
And the bottom bullet point here on this slide, any conflicts of interest ought to be disclosed at the outset of the hearing. So one of the first things that the board chair ought to do at the outset of the hearing is to ask each of the board members, are there any conflicts of interest? Is there anything that you need to tell us before we start this hearing about any situation that you think would prevent you from being a fair and impartial decision maker?
Is that public at the beginning of the meeting?
Yes.
Okay.
Yeah, because you
You want it to.
what happens is if that's in the record, and the question is asked, and the board members say, I'm okay. I don't feel like I have any kind of bias. A court's going to look at that and say, that's done. And that issue is over. I mean, unless you really do have a conflict of interest and someone can come up and testify about it and prove it, then you got other problems. But generally speaking, if the question is asked, the board is polled about whether they've got conflicts, and the answer is no, and no one contests that, that issue is decided once and for all. We talked a little bit about this already. Bias is having a fixed opinion that's not susceptible to change. If you're biased with respect to the application, you shouldn't participate in the hearing. Any ex parte communications about the subject matter of the application, that is when someone wants, you're having coffee on Saturday morning in the local diner, and someone comes up to you and says, hey, I know you got this application coming up and it really stinks and here's why. You should disclose that you've had this conversation. You don't have to be specific about who you talk to necessarily, but you can say a citizen came up to me and they said this, but it had no impact on my ability to be a fair and impartial decision maker. That kind of disclosure of the ex parte communication eliminates the issue. Next point was about site visits. My rule of thumb is don't do it, but if you do, disclose it.
So I have a quick question.
Yes.
It says, so if a person needs to, if they cannot be impartial, they recuse themselves. It's not like in the board meetings where you have to go through that whole process to be recused.
No, I think, and what I've advised my boards is that you have to disclose it and the other board members have to vote to let you be excused.
Okay,
I mean, you have to disclose it.
right.
You have to disclose it. And the rest of the board kind of decide. And again, my rule of thumb, as I've advised boards, is if one of your members thinks they can't be impartial, you let them out. Because once they say on the record they don't think they can be impartial, if they participate, you got an immediate grounds for appeal by somebody. So if a board member brings it up themselves and feels like they can't be impartial, I think the rest of the board, and this is not black letter law that's written down somewhere, but it's kind of the common sense approach. If a board member feels that they cannot be impartial, excuse them.
So if that happened and someone was excused and we didn't have enough numbers for quorum,
Then you can't make a decision.
can't make it, so, okay,
And you're going to have to figure out some way to adjust that,
okay.
or to address that.
Now, if we don't have a quorum, do we still have to put it out? We're gonna meet 10 days later,
Well,
the next meeting?
I think you can continue the hearing to a date certain, okay? And the reason I say to a date certain is because of the notice requirement. If you don't continue to a date and time certain at a specific location, then you have to go through the notice process all over again, which is administratively, it's kind of a difficult, and it costs a few more dollars, which we're all trying not to spend unnecessarily. So if you're in a situation where you've got a hearing that is open and you want to continue that hearing, you continue it, if at all possible, to a date and time certain at a specific location, so you don't have to do the notice all over again. Notice at the hearing is good enough.
And it doesn't need to be a certain amount of days or anything like that.
Not necessarily, no. I mean, you could continue the hearing till tomorrow night. And as long as you state that, you're fine.
Is it safe to go into that meeting with a backup date in mind?
Well,
So we don't have to pull out calendars and figure it out then?
I'll tell you, I'm not sure. It's the rare occasion that I've been involved in a hearing that was continued where everyone went in with a backup date in mind.
Okay.
Usually, I mean, believe me, it's okay to do that, but usually we've got people pulling out their phones, looking at their calendars, trying to decide
Okay.
whether, which Monday or Tuesday is the best day for them to meet.
Well, after tonight, we'll kind of have some sort of an idea if we're going to have a conflict, correct? Ish.
Well,
Depending.
I suppose that
Yeah.
you'll have an opportunity to see who the applicant
Right.
is and
And
what the
where.
application is.
Good
and
point.
Right.
That will give you some idea of whether any one of the board members might have some kind of, or think there might have some kind of conflict.
Now, you do have you have two alternates on the on this particular board, on the Board of Adjustment. Not on the planning board, but on
Right.
the Board of Adjustment, you have two alternates. So So you have a total of 7.
But only five, only
Right.
5 sit.
Who's
Right.
the 2 alternates? Just,
Um,
we said Mark Bringle.
and
And the-
Roxanne. is
Roxanne,
gonna do
okay.
that, But we'll have to get her sworn in.
Okay.
I'm a little bit concerned about those that aren't here tonight. If they have not received training, can they participate?
Well, they can still participate, but they're
Be behind the 8 ball. Yeah.
a little bit, yeah.
Yeah.
Which is
Yeah.
one reason we're recording this in case, so we can get our
Someone else
alternates
wants
called
to
up.
say- Exactly.
Okay.
And, you know, it's important, I'm glad you said that, because you don't, to the extent possible, you don't want to be in a situation where you go into the meeting with all 5 board members here, and you wind up with 2 having a conflict, or even just 1, and suddenly there's a concern about whether you can make a decision because you don't have enough board members to participate or to vote as a majority of the board. So having alternates or alternates available will be important.
I think it's safe to say too, Scott would be an alternate, the new planning board member. We can probably have that conversation with him.
You only have 2,
Right.
so you'll need to make sure, maybe talk to Anna about that.
I will.
think she's had some discussions around that.
Okay.
Because you want as much as possible to have a full panel,
Right.
a full, all 5 able to participate.
Which I think we should be fine.
Scott hasn't been sworn in either.
Yeah.
I thought we were doing that last night.
He was out of town.
Oh, okay.
Yeah.
I knew there was a reason, I just didn't know what it was. So, I mean, we weren't able to do that, so we'll have, that he can do that anytime in
Right.
the office. And then we just need to make sure that he has exposure to the training.
Okay.
Okay, this next slide about who may testify at the hearing, it's a little bit of a nuance, I suppose, as part of this. Applicants, individuals can obviously testify on behalf of themselves or on behalf of, if there's an entity, a corporation or an LLC or something, that is the applicant. Individuals may testify themselves or through their counsel. Opposition, same way, individuals or through counsel. Here's the kind of a tricky part, that different boards deal with this formality differently. Corporations or LLCs have to be represented by attorneys, okay? Doesn't mean that the individuals are not allowed to testify, but the president of a corporation is not, as a legal matter, allowed to represent in a legal proceeding the corporation. Cannot act like a lawyer. And I think that was kind of the lawyers' way to make sure that they always had something to do, right? Keep to stay busy. Make sure that entities that are really, not people, but are legal entities, corporations, need to be represented by counsel in judicial and quasi-judicial proceedings. I will tell you right now that is a rule that is more not observed than it is observed, particularly in small towns. And that's what I guess the 4th bullet point there is if you have an applicant who wants a non-lawyer to represent them, a lot of times what you'll have is a surveyor or an engineer who will present the case for a corporation. Most boards allow that to happen, even if there is no lawyer representing the board, representing the applicant. And unless someone makes an issue of it, it's a non-issue. But it's something just to keep in the back of your mind. That's strictly what the rule of law is on that. Is
But it
that
still should not be the applicant themselves.
right? Still not should not be the applicant themselves.
And that's an applicant, non-corporation, anything, right? It could be the applicant that's a citizen.
Right.
They still need someone representing them.
Right. If I want to put a porch on my house, but I need a variance because I won't meet the side yard, I mean, I might have the contractor or the engineer or the surveyor who's measuring the side lot line. I might say, gee, I'm a little bit nervous about making this presentation myself. Will you do it for me? And that happens pretty frequently, and that's okay.
But if it's an individual applicant, they can testify themselves.
Sure they can.
Okay.
Right.
They don't have to have an attorney, just if it's a corporation.
Right. An
or a-
individual, a person is always allowed to represent themselves, whether in court or in a quasi-judicial proceeding. An entity is not supposed to represent itself because the it's kind of legal fiction, right? The corporations are treated like people for some reasons, for some purposes, but with respect to legal proceedings, they have to be represented by counsel. Now, legal standing is a little bit of a tricky concept, and I'll tell you that the courts have kind of swung like a pendulum back and forth about how they treat legal standing in North Carolina. What legal standing basically means is that in order to be able to participate like a party in a legal proceeding, a person or an entity must have what I call is skin in the game. They have to be affected by the subject matter of the application in a way that is not typical of the rest of the public, not typical of the general population, in order to have legal standing. And what they say is that in order to have legal standing, you have to show that you would have special damages not common to the rest of the community if the application is granted or denied. Okay? So what does that mean? In kind of layperson talk, if I live 1.5 miles away from the site of the application and I don't like it, I can speak at the hearing, not as a party, but just as someone, an interested member of the public, and voice the reasons for my opposition. But if that application is granted, I don't have legal standing to appeal the application because I don't have enough skin in the game. That is, I will be affected by the application whether it's granted or denied, just like a member of the general public will be, like anyone else in town. The guy who lives next door, who might be affected by the granting of the variance that allows a 4-story building instead of a 2-story building, or allows a setback to be reduced from 20 feet to 3 feet, because I live next door and the granting of that variance might have an impact on my property value or on my use and enjoyment of my property, or may cause stormwater to flow onto my property where it wouldn't before, I'm going to be impacted by the decision on the application more than the general public. And in that case, I would have legal standing to participate as a party in the application. And here's what's important about participating as a party. If you have standing so that you'd be able to participate as a party in the application, you have the right to cross-examine the other side's witnesses. Okay? And that's a critical element of due process, is the right to cross-examine witnesses who are presenting an application or evidence that is against your interest. Okay? So using my prior example, if I live 1.5 miles away and I'm not, otherwise I can't demonstrate to you that I'm going to have some kind of special damages, if I think that the applicant's engineer is all wrong, and I think he or she is just doing a lousy job of presenting their case, I don't have the right to cross-examine that witness to show the board that their engineer is making a bad presentation. If I live next door and I'm opposed to the variance because there's going to be stormwater or impact on my property value, I do have the right to cross-examine that witness and to ask them questions like, well, have you done calculations about what the stormwater runoff would be before as opposed to after? And where does that stormwater go? I would be able to cross-examine that witness in an attempt to undermine their testimony. So that's why the question of legal standing can be an important issue in a quasi-judicial hearing.
I have a question.
Yes, sir.
How will Ryan go about asking their standings?
Well, here's my practical rule of thumb, is make sure when someone from the public gets up to say their piece, ask them where they live. Ask them, you know, where do you live, or where do you own property? You know, you might be a landlord who owns property next door to the site of the application. You might not live there, but your property is next door.
So it's a best practice to basically say when you introduce yourself, Ryan Nelms, 510 South Main Street.
Right, exactly. So, because one of the rules of thumb is proximity is, while it's not the be-all and end-all on standing, the closer you live to the site of the application, the more likely it is that you have legal standing to participate in the hearing.
But can any citizen in the town come and speak that night, even if they live on the total opposite side of the town? Or are we setting a mile range around?
Anyone can come. This is one of the important. That's a great question, because it's kind of a nuance that a lot of people don't grab. At a legislative hearing, for example, if the town council is being asked to amend the zoning map or to amend the zoning ordinance, at a legislative hearing, anybody can talk about anything, subject to the board's rules of procedure. In a quasi-judicial proceeding, while members of the public in general may be allowed to speak if they're going to present factual information to the board, okay? They're not allowed to fully participate in the hearing like someone would standing, okay? So if you live a mile and a half away, you're allowed to say, for example, I know that the traffic on Main Street is already bad, and that based on what they've said about the volume of traffic that they're going to add to Main Street, it's going to be a real traffic problem. That's okay. That's although it's an opinion, it's based on fact that's in the record. Now, the same person goes up there and says, I just don't like this application. Well, that's valueless to the board. It doesn't really mean anything. And while it's nice to know that they just don't like the application, it doesn't help you make your decision.
And that goes back to, I can dismiss that, correct? Or I can,
Well, one of the recommendations I would make is, again, at the outset of the hearing, when you start talking about the ground rules, you remind the public that you're here to determine facts and to apply it to the ordinance, and that opinions about I just don't like it, things like that, are that testimony won't be considered and is discouraged. Now, people are going to do it anyway, because that's what people do, because when they don't like stuff. But that really is not relevant, competent, or substantial evidence. So I think at the outset of the hearing, when you're kind of given your ground rules, you should say words that will discourage that kind of testimony.
say that again, opinions won't be, when you said like someone has opinion won't be relevant, is that what you said?
Yeah, relevant, so material, relevant, or competent.
Okay, thank you.
And those are all buzzwords that we'll talk about in a couple minutes.
Okay.
So the next slide, we've already talked about this a little bit. Who's got standing? The applicant has standing. Someone who suffers special damages has standing. Here's interesting, a homeowners association might have legal standing, or a property owners association might have legal standing to participate in the hearing. As long as one of the members of the association has standing, the association has standing. So I don't know, I don't know if that would be relevant in the hearing that's going to be coming up before you in a couple of weeks. But just something to remember, if you have a property owners association, if any member of that association would suffer special damages, if the application is granted sufficient to give that one person standing, then the association has standing to participate. Now, that's not to say that you should encourage every member of the association to get up and speak, but it is to say that that member of the association or some representative on behalf of the association should be allowed to participate to present the association's interest in the application.
If I'm a member of the HOA, and let's say I'm a member,
Okay?
will I still be able to be part of the judicial hearing, or no? I'd have to excuse myself. Like if I pay my HOA fees, does that make sense? Like I'm a resident of the neighborhood.
Well, I don't think that standing alone disqualifies you from participating. I mean, unless you feel as if that it makes you biased, and
I think
as
we only have two
individually.
neighborhoods that do that. Does your neighborhood have HOA?
Ish.
Okay, I'm just thinking.
Yeah, I don't think the fact that you're a member of the HOA and the HOA might have standing disqualifies you from participating as a board member unless you say, I don't think I can do it.
Okay,
We have one, it's just not enforced, and you don't pay into it.
okay. It's a club.
So
Then you don't have it if you don't pay.
this next
He
slide.
enforces his part, the developer does.
This next slide, we've already talked about this really, about what it takes to have standing. You have to show you have some kind of special damages. Proximity is not the be-all and end-all, but it's a good first step. The closer you are, the more likely you are to have standing. Decreases in property values, that's always sufficient to convey standing. Other impacts like traffic, parking, stormwater, litter, glare, noise, dust from construction, those things all might be enough to convey standing on a person. Talked about this a little bit. Standing should be determined early on. With respect to the parties, surely the applicant has standing. You don't have to worry about that. The opposition, you do want to try to glean whether members of the opposition have standing as early in the process as you can. I've been involved in some hearings where, and I'm not suggesting that you do it this way, but it's something to think about depending on the nature of the application. I've been involved in hearings where we did what we bifurcated the hearings, okay? Where the first issue we dealt with was standing. If there were 15 people who said they thought they had standing and wanted to participate, the first part of the hearing we spent on nothing other than determining whether they had standing. And that would be, asking each of the potential participants, where do you live? Where do you own property? Describe to us how this application and the granting of the application would impact you. And then, based on what the information is, what the testimony is about that issue, the board could determine you have standing, you don't have standing. And if someone doesn't have standing, it doesn't mean they don't get to say their piece later on. But what it does mean is they don't get to cross-examine witnesses later on. Okay? 9 times out of 10, probably 95 times out of 100, it's very clear who has standing. I mean, there just aren't that many people generally who would have standing to participate, so it's very easy. But if you have a lot of people, I mean, it may take you a half hour at the beginning of the hearing to sort out who's got standing and who doesn't. Okay, now the conduct of the hearing themselves. The applicant always has what's called the burden of proof for the application. That is, the applicant has to establish or present evidence to the board sufficient to allow the board to determine that they've met the standards required by the ordinance, either for a variance or for a special use permit, or to convince the board that the interpretation of the zoning administrator that is being appealed is incorrect, okay? The applicant has the burden of proof. And that's what that slide basically says, exactly that. One of the differences between legislative hearings and quasi-judicial hearings is that for quasi-judicial hearings, all the witnesses have to be sworn under oath, just like in a courtroom. In a public hearing about a zoning amendment, no swearing is required. That's a legislative decision. In the kind of application that you'll be hearing where there's going to be evidence presented and testimony, all the testimony has to be presented under oath. And usually what we do, if you have a room full of people at the beginning of the hearing, when you're getting ready to open the hearing to testimony, you say, anybody in the room who thinks they might want to testify tonight, please stand and be sworn in. You do a mass swearing in. It saves you a lot of time. Because if you have 25 or 30 witnesses, if you got to swear them in each one at a time as they come up, it just takes you that extra minute to do that.
Do they bring their own Bible with them to be sworn in on, or?
Well, you don't need, they could. Yeah. I just say stand there, raise your right hand,
Okay, cool.
and repeat after me.
Who swears them in?
The chair.
Okay.
Okay, one question. So do our alternatives, are
Alter-
they, I
alternates?
can't say the word, and
Alternates.
I'm English. Alternates, are they sworn in
English
already?
teacher?
I know, I said I couldn't get it out.
Well, that's a different swearing in. They have to take the oath of office.
Right, well, but that happened to me in the last meeting, like, have they had the oath, the alternates, if
No.
there was a need then? They
Yeah.
will before that day?
They will.
Can't participate if they haven't.
Right.
before then.
Right,
So they'll be sworn in.
okay.
And you won't be testifying.
Right.
So you don't need to be sworn in. As long
Right,
as
it's-
those people are going to be testifying.
It's not the board members who have to be sworn, who
But
have
to
to be sworn in.
vote, they would have to be.
They don't
No.
get to vote.
No.
Y'all vote. This is the people sitting in the audience.
Yeah, I was just thinking about the alternates, if we were to have them,
If
would they have,
If
They would
we
have
need them
to-
for quorum, yes, they would
Right.
vote
Right.
right,
during the hearing.
but
And they would need to be.
they would need to be sworn in,
Yeah,
yes,
yeah.
and
Before
so
they could be a board
if
member.
Meredith's not here to do that, like what happened for me, would that need to take place?
Amber or Meredith can swear
Okay,
them in.
okay,
And they can do it.
Everyone will be here.
okay.
Yeah, they
okay.
can. They'll get it done next week. Like
Got
they
it.
just stop by the town.
Oh, it doesn't
Like
have
we
to
got
be like
sworn in
a
the
public-
lobby.
No.
Got it,
I don't
got
know
it.
about
it
you,
can
but I got
be-
sworn in the lobby of town hall.
Yeah,
So-
you know, it could be 2 minutes before the hearing
Got it, got
starts.
it.
Yeah.
Okay, I'm with
You
you.
know, quick swear 'em
Yeah.
in. So
You got fancy treatment. Getting sworn in during a
special treatment.
planning board meeting.
Gotcha.
So
I thought that's how it all went.
So all the witnesses, including the staff, if you have a staff member who's going to make an initial presentation, need to be under oath when they testify. All the board's decisions have to be based on substantial, competent, and material evidence in the record. We'll talk about those standards in a few minutes. Only the parties can examine or cross-examine witnesses. Again, that's kind of what's, the standing issue has a lot to do with that.
when I swear them in, is that just like, do you swear to tell the truth,
The whole
nothing
thing's
but
nothing
the
but the truth,
truth?
so help me God.
Yeah. Okay. Cool. Like
Yeah.
people's court.
Yeah, exactly.
Judge Judy.
That's what I feel like right now.
Judge Judy or Judge Joe Bryant or whatever, they do a fine job of
Judge
that.
Ryan,
Get your robe.
Can you? I want a collar. What's that called? The bib or whatever. Yeah.
Oh, the RBG.
Yeah.
good thing,
I will RVG it up. Yes.
And one of
I'll
those
get a
big-
bun, too.
One of those big white
Yes,
wigs.
yes.
would be-
Like they used to wear like Ben Franklin did.
There you
So I finally get to use the gavel. Is that part of this too?
Sure.
Order.
Oh,
speaking of order,
Houston, we have a problem here. We got a board member out of control.
speaking of order, I've been actually, I didn't realize that this is what this was called, but I went as a supporter, a silent supporter. We just wore t-shirts. However, it got very heated to the point that security had to take people out.
I've seen that happen.
So will we have someone here to be able to do that if it got to that point?
Are we have police present?
We can.
We have firemen present. Can they escort people out? Like,
We can have police
Okay.
present
If you let a fire, they can.
I mean, I don't know what it's about, so I don't know. But the one that I went to was
Well,
really bad.
the hearing I was at last night, there were almost 200 people there, and there were sheriff's deputies
Same.
there.
The one I went to was-
Because it was a very controversial application, and,
Yeah.
I mean, everything was fine, thankfully,
Yeah.
but there had been enough heated debate in the public before the hearing that we thought it was smart to have police presence, so. Last bullet point, very important. Once you've closed the hearing, no new evidence. You may ask some questions of the applicant or the opposition just to clarify things they've already said, but you really, once the record is, the hearing is closed, the hearing is closed. Competent evidence. What does that mean? It means that the person who is testifying is qualified to give the testimony. So if you want testimony about real estate property values, it should be someone who's got a real estate background. It really ought to be an appraiser, quite frankly. But it can't just be Joe Jones who says that he thinks that that property over there is worth $50,000. I mean, that is not competent evidence unless Joe Jones can say, here are the facts based upon which I reach my conclusion, and I'm qualified to make that conclusion. What is material evidence? It's evidence that's important enough and related enough to the issue before you that it would make a difference. So that if the application is about the height of the property or in a variance application, and if that's really the only issue, should we grant the variance for the height of the property? The fact that there might be a drainage problem is not material to the application. So you don't really need that kind of evidence. Substantial evidence, I've always loved this, is there's one definition in some case law that says that substantial evidence is more than a mere scintilla, but less than a preponderance. And if you get nothing else out of this tonight, remember that substantial evidence is more than a mere scintilla, but it's less than a preponderance. And what it is, it's enough evidence so that a reasonable mind could say, yeah, that makes sense to me. It supports the proposition for which it's being offered. It doesn't have to be, there can be no other conclusion, but it's got to be enough for you to sit there as a reasonable person and say, yeah, that makes sense to me. That's substantial evidence. Lay testimony versus expert testimony. A lay person is just the ordinary person on the street who can say, for example, yeah, there's an awful lot of traffic on this street, and I know that because I live on this street, and if you add the hundreds of cars that are going to be added by this development, it's going to make things worse. That's lay testimony. Opinion testimony is typically not offered by a lay witness. Opinion testimony is usually the bailiwick of experts, unless the lay person, like I said before, can say, I know there's going to be a lot of traffic here because I live there, I see what the existing traffic is, I've heard what they said about additional traffic, and it's already bad, adding more is going to be worse. I think that's competent lay testimony. Expert, for example, would be the engineer talking about increased drainage and how stormwater runoff is going to be handled on the property. Or it might be a traffic expert who can tell you that the intersection of Main Street and whatever the next street is here now operates at a level B, and if we add all this traffic to it, it's going to now operate at a level C. That has to be expert testimony presented by a qualified traffic engineer who can tell you what their qualifications are and what the factual basis, the foundation for their opinion testimony is. Experts usually give opinion testimony. And the bottom note there, I think, is pretty important. When an expert gets up to testify, if the attorney or whoever doesn't provide you with their qualifications, you should ask them about the qualifications. And if they're an engineer, ask them, are you licensed by the state of North Carolina? Where'd you go to school? What degrees do you hold? Have you ever testified as an expert before? Have you ever worked on projects like this before? Just to create the record and get to understand their qualifications. Again, that'll be important for the record later on if there's ever an appeal.
So you may be getting to this later, but I just had a question. So I'm trying to think about how this thing starts, continues, and finishes. So do you have opening statements? And then, because some of these people just want to make a statement, but they aren't going to be witnesses. So how does that work?
Some of what?
Like you had said, if someone wants to come up and make a statement, if they live a mile and a half away, and they want to say, well, my experience is that driving through that intersection at that time of day, and there's a lot of traffic already, and this would add more, that person is not really wanting to be someone who is an expert witness or someone who even has standing. They just want to make a statement. So when does that happen?
So here, the way it usually goes, kind of the order of events, is you open the hearing, the staff makes the presentation of the staff report, which may be as simple as XYZ Inc. has made an application for a special use permit to build a widget manufacturing plant on Main Street. And that's allowed under the LDO with a special use permit, and the standards for a special use permit are X, Y, and Z, and the representatives of XYZ Corporation are here now to present their case. So you have the staff presentation, then typically you let the applicant go because they've got the burden of proof, so they would present their case. You know, it might take them a half an hour, it might take them 45 minutes, or, you know, you just have to give them enough time to present their case. Then, if there is any, I'll say, organized opposition, you let the organized opposition present their case. Then, if you have individuals who want to speak, to testify, then let those individuals speak. And those are the people who probably don't have, when I say individuals, they're probably people who do not have standing.
Right.
Maybe they do. But, you know, if there are a lot of people who want to speak, one of the first things you want to do, again, is to find out whether they've got standing or not, or whether it seems like they probably have standing or not. And that's, you know, asking the questions about where they live and how will this impact them. Then, usually there's an opportunity for the applicant to rebut things that were said, because usually these things, well, not usually, but sometimes there's just a lot of mudslinging that goes on, and people say things that just don't make sense. And the applicant needs an opportunity to say, well, what Johnny Jones said doesn't make sense, and here's why. And at that point, there may be a closing statement by the applicant. Now, something to remember, and this is in the presentation, the board members always have the opportunity to ask questions, okay? So that when the applicant is making their presentation, what I recommend is that you allow them to make the presentation. If you have questions, make a little note about what your questions are. And before they sit down and you let the opposition, so to speak, ask any of the board members if they've got questions. And, you know, it's whatever questions you have, they're fair game. I mean, you have to be satisfied, you have to be comfortable with your understanding of what they're trying to tell you. So don't be shy about asking questions. Same with the people who are opposed or who are offering testimony against the application. Feel free. It's part of your job, again, to gather the information that you think you need to make a good decision. So, you know, you always have the right to cross-examine witnesses from either side. Again, a little more, we already spoke about the lay versus expert testimony. Typically, opinion testimony is offered by experts, but there can be lay opinion if it's based on well-grounded facts that are presented to you at the hearing. A lot of times, you'll find that someone will get up and they'll say, well, I went on the internet and I Googled whatever, and I printed out this report, this 97-page report, the conclusion of which is that this application is bad, okay? Neither the report nor that testimony are really material or competent. Ordinarily, what I do is I let them hand it in, but for that kind of testimony, you give it the weight that you think it deserves, okay? Which generally is not much. Because whoever wrote the report, even though they may be a competent expert witness, they're not here to be cross-examined. And if they're not here to be cross-examined, you really can't give their 97-page report much weight. Okay?
So if that happens and they hand in that report,
Mm-hmm.
what is the action on my part? Who do they hand that into? Me?
You, or I don't know if you'll have a clerk sitting here helping you, but
Okay. And do I have to look at it? Do I have to, if I don't, how do I just say this is not?
say, well, you accept it
Okay,
and say thank you.
okay. Okay, cool. I just want to make, I want to make sure that's not too
Yeah.
rude or blunt. And
No, no. Yeah, so,
Yeah.
You know, it's tough to say thank you, and I have,
Put it in the trash can.
and I've said at hearings before, you know, we will give it the consideration that it deserves,
Okay, okay.
and which usually, well, often enough is, it doesn't deserve much consideration.
Okay. Is the goal that night we make the decision of what we're going with?
Well, I think as a general rule, boards like to make decisions on the night that the hearing is conducted.
Okay. Do,
There is no rule, no statute, no law that says you must make the decision that night. Now, for example, I have a rule of thumb that no good decisions are made after 11 o'clock, okay? So if you have a hearing that's gone on and is still going on at 11 o'clock,
I was thinking 10.
I
I know, right? I mean,
but that, you know, that's something, really as a practical matter, at the beginning of the hearing, when you're talking about your,
Yeah.
kind of setting the ground rules, one of the things you might say is, you know, our goal is to be done here or to be deliberating at 10 o'clock. And if we get to 9:45 and it looks like we're not going to be done, then maybe we got to talk about what we're going to do.
okay, so so that just be calling a recess at that moment?
Right.
Am I using?
To
those
call a
terms?
recess to talk about it, right? If you're going to continue the hearing
Okay.
to another date, then at that point, the appropriate action would be a motion to continue the hearing
Okay.
to a date and time certain and location certain, where testimony can pick up. If you're at a point where you've closed the hearing, but you guys are just confused and dog-tired, and it's 10:30 or whatever, it's okay to at that point, recess the meeting to be continued at, again, pick a date and time certain. You don't have to worry so much, the hearing is closed.
Okay.
You know, but if you need time to have a fresh mind and to consider the evidence, don't feel pressured to make the decision that night if you're not ready to make the decision.
Okay.
And also, don't close the hearing until everyone's told you everything they need to tell you. And, you know, if everyone's told you everything they feel like they need to tell you, and you don't think that you can approve the application, then, you know, that's the way it is.
Do we ever have cases where there's no opposition?
Oh, yeah.
Okay.
Those are the best cases to have. It's easy.
Okay.
Because then you only have really one side's story, and you just have to decide whether that story is enough to meet the standards in the ordinance. And if it is, you approve it. And if it's not, deny.
And do we have moment to like speak amongst ourselves, or are we doing everything right here?
You have to do all your deliberations
Okay.
in open,
Okay.
in public. Yep.
Okay, that's what I was.
Almost kind of like a jury, and you got to-
That's what I was hoping for too.
Yeah.
I was
yeah,
wondering where we were
It's all
going.
got to be done in public.
We need a.
You know, if,
So can the police officers follow us home?
when I practiced in upstate New York for 13 or 14 years, and I was working in private practice for representing cellular telecommunications towers developers. Okay, this is back in the late 80s and early 90s. And there were a lot of small towns where back then they didn't want to have cell towers. And there were some meetings where we needed a police escort to get out of town. I mean, literally, because that happens sometimes. But I mean, those are infrequent, and hopefully that will not be the case here. But sometimes these hearings get heated. Yeah.
I'm parking right back here and walking in through the fire station. I'm just gonna call that.
So here's an important slide right here that we're looking at now, and it's important because there are 3 situations in which expert testimony is required. That is, that lay testimony is insufficient. One is regarding how the use of property will impact adjoining property. Really, that's property value. The second one is traffic. It used to be in North Carolina, Mike Bro, or my firm's namesake, he always said that whenever there was testimony that increased traffic would be dangerous to children, didn't matter who testified to that effect, the application would be denied because no one wanted to have a kid hit by a car. Okay. Now the rule is testimony about the impacts of an application, the traffic impacts of an application, has to be presented by a traffic expert, and that is usually a traffic engineer. And then you're not going to run into this third situation, matters about which only expert testimony would generally be admissible. Well, you do run into that with perhaps like stormwater and drainage impacts, and testimony about utilities and sufficiency of, say, your water and sewer systems to accommodate the development. So that's the kind of testimony that has to be presented. Usually the wastewater, stormwater, water, sanitary sewer, usually you have some kind of an engineer who's providing the testimony on that. But it's usually the opposition who want to testify about that and don't have a qualified expert to testify about that. And that's where you run into the issue. But testimony about subject matter such as that needs to be by a qualified expert. Hearsay evidence. Hearsay evidence is when, maybe you already know this, when someone testifies that someone else said something. And that testimony, you're saying, if John said that Jimmy said that, then it must be true that Jimmy said that, and what Jimmy said must be true. That's hearsay. Hearsay evidence in court usually isn't, well, I shouldn't say usually isn't, often isn't admissible. There are about 27 rules, exceptions to the hearsay rule, so there's lots of times when hearsay is acceptable. In a quasi-judicial hearing, it's not preferred, but it may be admissible hearsay.
Who dismisses it? Me? Cool, I just want to make sure.
Well-
When that happens, I want to make sure I know.
Well, if someone objects to it, saying, "Hey, that's hearsay," I mean, you have to think about that, and if it doesn't make a difference, I mean, there's lots of times in courtrooms where hearsay evidence is admitted because no one objected to it, and it really doesn't make a difference to the case.
Okay.
It's not material.
Okay.
But if it's an important element, for example, if they're talking about stormwater runoff and the impacts of stormwater runoff, and there's a report that says, yeah, there's going to be a lot of stormwater caused by this application, but the stormwater engineer isn't there to testify, but only his report is there, the report is hearsay. And it may be really, really important to your determination. So, that's, and it wouldn't be good enough for the attorney to say, well, here's our engineer's report, and here's what our engineer says about stormwater. In that case, I might think, you know what, I really need to have that engineer who wrote that report here to explain that report to me. And so I would at least consider saying to the attorney who's trying to get the engineer's report in without the engineer being here, saying, hey, that's hearsay, and I'm not inclined to accept that report into evidence unless the engineer who wrote the report is here to testify about it.
Okay.
So, so with hearsay, it really has to do with what is the relevance and the materiality of the issue about which the hearsay testimony is being presented.
Before he kicks out the hearsay, does he talk with us about it? About dismissing the hearsay?
Well, I think that the chair makes the ruling on that.
Okay.
Now, if I were him, I'd probably talk to the rest of the board about it. But
Would that be a motion I would make or anything like that, or just say, I believe this is hearsay, can I have your,
I think you would make the rule. You would make the ruling on that.
Okay.
It doesn't have to be a
Okay.
motion.
okay.
Let's see.
But you could say to them, is anyone opposed?
Right.
Yeah, okay.
And you can have some discussion about it before you make your final decision on it.
Okay.
You know, get if you're uncertain or if there seems to be a feeling on the board that maybe not everyone agrees, talk about it.
Just gotta do it right here from God now.
That's right. That's exactly right.
I regret living on Main Street.
The second bullet point there, which is important,
Make your house very,
is that let's use that stormwater report as an example. Okay, suppose you admit that report into the record and it's hearsay and the engineer wasn't here to testify about it. If the issue upon which the application approval or denial turns is the stormwater design, you can't approve the application based on the hearsay stormwater evidence,
Right.
because the guy who's competent to testify about it wasn't here.
And so there's no, at that point, could you stop and
Well, you
and
could
say we would only be able to continue
you
it?
could continue the hearing
Yeah.
and say, we're not prepared to deny it
Okay.
because we think otherwise it might be good.
Right.
But you could
We need
deny
the
it.
expert.
You could deny it that night, or you could continue the hearing and say, we're continuing the hearing in order to give the
Okay.
stormwater expert an opportunity to appear and testify in front of us. That's, completely up to the board. Business records, usually in Board of Adjustment hearings, you don't run into much business record kind of issues. That's like, well, I'll use an example. If a prior decision by the Board of Adjustment becomes there's some kind of precedent. One of the records you keep is your minutes. It's a business record. The minutes, the official minutes, approved minutes of the Board of Adjustment might be an admissible business record. And the best practice, heed the best practice, the person needs to be at the hearing to testify about the fact. We've talked about that. Rebuttal evidence. So once you have, the applicant has their burden of proof, the opposition gets a chance to present testimony in opposition, then usually the applicant, like we talked about before, has one more chance, one more shot to kind of rebut some of that, the testimony, to reestablish the bona fides of their application and their evidence. Building the record, the underlying theme is North Carolina law requires all quasi-judicial decisions to be based on evidence in the record. And that's why you don't talk to people about, there's no ex parte communications. It has to be based on the testimony that's presented to the board and the documentary evidence that's presented to the board and entered into the record of the hearing. Things like photographs, and this, it may seem simple, but often enough, there are photographs that are presented to demonstrate to you what the condition of the property is now, or to show you what the building is going to look like. But particularly with situations where someone wants to show you, for example, that there's a lot of stormwater runoff during rain events in and around the property. They'll take photographs and they'll present them to you. What you want to be able to do is, or what whoever is going to present those photographs to you should do, and you should require them to do, is to say, tell you who took the photograph, when they took the photograph, and for them to say, and this photograph accurately represents the conditions that existed at the time I took the photograph, that it hasn't been photoshopped. What you want is to have the evidence authenticated so that you have the foundation for it, basically, that you know that it's an accurate portrayal of what it is presented to the board to portray. Again, that's usually more of an issue in a courtroom than it is in a Board of Adjustment hearing. But, you know, if it comes up, you want to know a little bit more about the background of the photograph, okay?
What if the applicant remembered they had a photo and it was on their phone? Would we take that into, or only physical pictures?
Well,
My mother-in-law watches court shows all day, and I get sucked into them once in a while, so.
It's on my phone.
you know, I guess I've had that happen, and at a hearing a few years back where the only photograph was the one that was on the phone. And we accepted it into record, but we made them produce a hard copy of it for us ultimately.
Okay.
Or an electronic copy of it. But we didn't want it to be, you know, the only place where it existed was on that person's phone, so that if there was ever an appeal, we'd have to subpoena that person's phone to bring
Yeah.
it to court.
So we could request to have it emailed to the clerk
Yes.
and everything was,
Yes.
okay. That's why I'm asking all these questions, 'cause I'm going through all these shows I've watched.
You watch too much Judge Judy.
I don't, she does.
Yeah.
And that's on
Let's-
the record and videotaped, I love you.
In case she's watching this.
Building the record, this slide, I don't think there's really anything that's too noteworthy on it. Witness testimony may provide facts if it is competent, material, and substantial. You know, again, competent evidence is evidence offered by someone who's qualified to give it. Material is that it's is that it addresses something that that is substantial enough to be important, and substantial, that it carries a little bit of weight, that a reasonable person could say, yeah, it makes sense to me. Facts may be inferred from testimony. I mean, that's kind of like Johnny has the gun, Johnny points the gun, Jimmy gets shot. No one necessarily saw Johnny pull the trigger, but the inference is that Johnny pulled the trigger and shot Jimmy. I mean, that's what the inference is. And the last one is kind of a subtle point that what everyone knows may not be the fact. There's lots of stuff out there that everyone just assumes and believes to be true. But when you drill down into it and you really look at it, it turns out not to be the case. So, you know, someone may tell you, well, everyone knows that. Well, everyone thinks they know that, but that doesn't make it a fact sufficient to base your decision on. Basic rule, you can only make your decision based on the evidence that's in the record. You can't make your decision based on anything that's not in the record or that's presented after the hearing, the hearing is closed. And this is a point I was trying to make a little while ago, is do not be shy about asking questions, because ultimately you have to make the decision. It's your responsibility. You need to be confident that you've got enough information so that you feel comfortable making the decision. So if you're not sure, if you don't understand what someone is testifying about, don't be afraid to ask questions. I mean, I always tell clients are always afraid to ask stupid questions. And, I always say there are no stupid questions. There may be stupid answers, but there are no stupid questions. Ask questions. But special use permits, and I refer to different sections of your LDO about where these standards are found. The applicant has the burden of proving with a special use permit application that, first of all, that the use is permitted with a special use permit in the table of permitted uses. Usually your staff has reviewed the application and has already reported that, yep, the manufacturing plant that they want to build is allowed in the M1 district with a special use permit. So that's one of the findings that you have to make, that the use is allowed in the district. That the application is complete. Typically, your rules require that the application contain certain information. And usually your staff has already reviewed the application, has determined its completeness. Otherwise, the application wouldn't be set up for a hearing. But you have to be, the applicant needs to satisfy these burdens. And that if the proposed development is built as proposed, that it will comply with the requirements of the LDO. Those are your three basic threshold findings. And again, usually, if the application is in front of you in the first place, those first three findings probably aren't contested. Now, here are the four typical findings that you need to make all four of these before a special use permit can be granted. If the applicant satisfies three of them, but not the fourth, you have to deny. So the first finding is that, this is a general finding, and these findings, just so you know, are typical throughout the state. I mean, some ordinances say them different ways, but they're really the four findings that need to be made. First, that if the development is built as proposed, that it will maintain and promote the public health, safety, and general welfare. That no one's going to be hurt by it. Okay. Second, that the proposal complies with all of the regulations and standards contained in the land development ordinance, so that setbacks, how stormwater is addressed, any buffer requirements, parking requirements, that the application, either the plans themselves or through the testimony, demonstrates that all of the applicable requirements of the LDO are satisfied. Third, you almost always have an issue, especially with controversial applications, about impact on a nearby or adjoining property values. In your LDO, the standard is that the use, if developed as proposed, will not substantially injure the value of adjoining or abutting property. Now, what's interesting about this is that it might be that there could be some injury, some little injury to nearby or adjoining property values, and you can still approve the application. The key word there is substantially. All right. So if the property value is $100,000, and if you approve the application and the development is built, the property is now worth $99,000. The question is that have they been substantially injured? If you have a $100,000 property that's now going to be worth $50,000, I think you have a pretty clear case that that's a substantial injury to an adjoining property value.
So who would be the expert?
There ought to be a
On
real
that.
estate appraiser
Real
who
estate
testifies
appraiser.
about this.
Okay.
Yeah. And the fourth qualification is that the use is in harmony with the area. There's case law out there that says basically that because the elected officials, the legislative body, has said that the use is permitted in the district if you satisfy all the other requirements, that's tantamount to a finding that the use is in harmony with the district. Okay? So usually harmony is not an issue. A lot of times testimony is presented about the impact of the use on the character of the area. But there has to be really good, strong testimony about that in order for that to be a basis upon which you would deny an application. Because harmony with the area is usually implied by the fact that the use is allowed in the district to begin with. So the variance standard is a little bit different. And remember, in North Carolina, there's no such thing as a use variance. You can't say, an applicant cannot ask, and you can't allow them to put a manufacturing use in a district where manufacturing uses aren't allowed, okay? So you're not allowed to, that's basically rezoning the property. And only the Board of Aldermen can do that, the legislative body. But with a variance application, where, for example, I'll use my height variance just as a for instance. If there is some character of the land that makes it difficult for the property owner, the applicant, to reasonably use the land without the variance, and they can show you that there's some hardship that's created by the character of the land. It might be that there's steep topography, or that my variance, my height variance is probably a bad instance of this, or that there are stream buffers that run through the land so that only a portion of the property can be used. That's a hardship, okay, caused by the character of the land, not a condition of a person, for example, that might be sufficient to justify granting a variance. Now, zoning regulations in themselves impose some hardships on everybody with respect to how they use their property. And that's, zoning ordinances restrict the use of property in some ways. So not every hardship is unnecessary. The key component, the key factor when looking at a variance application is whether there is unnecessary hardship that is caused to the property and the property owner and the way they want to use the property due to the characteristic of the land and the application of the requirements of the zoning ordinance. So that, you know, maybe using a setback is a better example. You have a piece of property where there's a stream that runs through the middle of it. And let's say it's a 10,000 square foot piece of property. And there's a stream that runs through the middle of it, so that you really only have a 5,000 square foot envelope within which to build your house. And if your setback requirement, say your front yard setback requirement is 25 feet, and your rear yard setback requirement is 25 feet, so that you can only build a 12-foot wide house on the property, just using crazy numbers. You know, with that, I think you could say, well, having only a 12-foot wide house might be considered a hardship. It's caused by the strict application of the ordinance. That is, you have a stream buffer running through the property, you have a 25-foot front yard setback and a 25-foot rear yard setback, and we just can't build a wider house unless we get some relief from that setback. I mean, that would be a situation where you have unnecessary hardship and the granting of a variance would seem appropriate. Point two, the hardship results from conditions of the property. We've had situations where, for example, someone wanted to have a house built right up to the setback line, and they want to build a porch on the side of the house, but they just can't, don't have enough room there. And they want to build that porch because they have a hobby that it's best to have a ventilated porch room on the house. Has nothing to do with the condition of the land, has something to do with the personal preferences of the landowner. That's not a sufficient basis for granting a variance. That is, that I really want to conduct my hobby on my porch, and in order to build the porch, I need the setback variance. I'm going to tell you that usually in a situation like that, unless someone comes in and opposes the application, many boards will grant that variance. But if you strictly apply that criterion, they're probably not legally entitled to the variance. The hardship did not result from actions taken by the applicant. This is the self-created hardship standard. When somebody created their own problem, and now we're asking you to relieve them from the problem they've created, if the hardship is self-created, they're really probably not legally entitled to the variance. And then the fourth factor is kind of the catch-all. You know, if you think that granting the variance unfair, or did you think that granting the variance is necessary in order to do justice, because it is fair to this property owner to do it, then safety is secured and substantial justice is achieved. In order to grant a variance, you have to make all four of those findings. If you can't make any one of them, you can't grant the variance. Okay? Non-conforming situations, I won't spend a lot of time on this. Basically, the public policy is that non-conforming situations should eventually be eliminated. And the rule generally is, and it's in your LDO, that you shouldn't allow nonconformities to be expanded or continued. Okay? So you don't want to make a nonconforming setback more nonconforming. If a building is already too tall and someone wants to make it taller, you can't do that. You can't do that through a variance or any other kind of situation like that. This slide kind of reinforces a little bit what I was talking about a minute or two ago about each of the standards. Unnecessary hardship to be peculiar to the property, not to the property owner. The hardship should not be self-created, and granting the variance should advance public safety and assure that substantial justice is achieved. The board may attach conditions to special use permits and to variances, but you can't attach kind of crazy conditions. The conditions have to be geared towards making sure that it's kind of related to the use that's being proposed for the property, doesn't really conflict with the spirit and intent of the zoning ordinance. There's case law out there, this Overton versus Camden County from back in 2002. When you're asked to make interpretations of the ordinance, you're not really allowed to attach conditions to interpretations. Your interpretation is either yes or no. It's not a yes but only if. Whereas, with a variance, you could attach some kind of reasonable condition to the variance or to the special use permit. Reasonable accommodation, this usually has to do with Fair Housing Act and with group homes. There are requirements under federal law that with respect to group homes and the like, that zoning regulations be relaxed in some circumstances in order to make sure that there is housing available for people with disabilities. I mean, that's kind of the bottom line on that. I won't spend a lot of time on that because those kinds of situations occur relatively infrequently. But if they should occur, if it does come before you, you know that there is a requirement to make reasonable accommodations under the circumstances that we've described there. Appeals of staff decisions. I mean, basically, your zoning administrator makes initial calls about whether to issue zoning permits or building permits. They may have to make calls about where the setback line is measured from or measured to. If a property owner is aggrieved by that decision, the appeal is to the Board of Adjustment. So in those cases, once there's been a final and binding decision by the zoning administrator, that becomes an appealable decision that may be brought to you for a quasi-judicial hearing. And there are no specific standards like there are for SUPs and for variances, but you are asked to apply the definitions in the zoning ordinance. If there are no definitions, you use dictionary definitions. There are just some general rules about using common sense to apply and to determine appeals from determinations by the zoning administrator. On appeals of staff decisions, the staff person who made the decision must appear to testify in front of the Board of Adjustment. All the information that the staff person had and based upon which they made their decision has to be part of the record that's brought before the Board of Adjustment. And in those cases, you're allowed to make the decision, whatever decision the zoning administrator could make, the Board of Adjustment is allowed to make on appeal. Rules of ordinance interpretation. In a court will give deference. They will generally give deference to the zoning administrator's interpretation. Boards of adjustment typically do give greater weight to the zoning administrator's determination than they would to someone else's. But that's not to say that zoning administrators sometimes make mistakes. And if the Board of Adjustment feels that by applying common sense or applying definitions from Webster's Dictionary or from the zoning ordinance, that the zoning administrator has made an error, to reverse that decision. here's an important point with respect to variances. Whereas with special use, simple majority vote is sufficient to grant a special use permit. With respect to appeals from zoning administrations, a simple is sufficient to grant the appeal. To variance, you need a supermajority vote. You have to have at least 75% of the board has to vote for it. In cases, what does that mean? That means that you got to have 4 out of 5 of the board members vote to approve a variance application. A 3-2 vote is not good enough. When you make a quasi-judicial decision, it has to be written. You have to make findings of fact, the facts upon which you base your decision, and then make your conclusions of law. That is, and here's how these facts support the decision based on section, 3.2 or whatever. All right? So you can't just make your decision on a simple motion, I vote to approve the application and be done with it. You've got to, and the way this happens frequently enough is that the board goes through and makes its decision and explains its decision on the record when you make your decision, and then the decision is reduced to a written order, and then at the next board meeting, the board may approve the order and it becomes final. In some circumstances, the board makes the decision, it's reduced to writing, and the board is authorized to sign the order before the next, because that just saves time. And that's a matter of different jurisdictions do it different ways, whatever you're more comfortable with. Especially in contested cases, the board has the board's attorney write the decision, just to make sure that the legal I's and T's are crossed.
So I have a question on that. When we refer to the board's attorney, so the board of aldermen have an attorney.
Mm-hmm.
Attorney with
The staff.
staff.
Appointed to represent the board.
Okay.
Yeah, that, we run into that all the time, and, I mean, with the towns we represent, we run into it, and a lot of times, in towns that we don't represent, we're called in to be the board of, and not to be a conflict. The town's attorneys represent the town and the town staff. Want to make sure they're independent, because the Board of Adjustment is really independent of the Board of Aldermen, So you to make sure that you don't have conflicts. So that's the way it typically happens. There is a controversial item where you think that there may be an appeal that could happen. You really are fastidious about how thoroughly the decision is written. Make sure you have some outside counsel who comes in and represents adjustment just with respect to that application. Some bigger towns have separate Board of Adjustment counsel, like Chapel Hill had, which is 50 or 60,000, a little different than Landis. They have an HDC, a Historic District Commission attorney, and they have the.
So one question. So we put that in writing. I would sign it. And we only have Board of Adjustment meetings quarterly.
Mm-hmm.
Would we have a call?
Well, either a special called meeting, because I get where you're heading with this. Making someone wait another 3 months just doesn't seem.
Yeah.
So either you establish a practice where the draft order is written, it's circulated among the board members, one at a time, not in a group email. Any comments are made, and it's finalized, and you're allowed to sign. It could be 3 days later, or you have a special meeting to review, and then the board authorizes you to sign.
Okay.
And that's a matter, there's no rule of law on that. It's a matter of your local practice.
And then when we do that and I sign it, the Board of Aldermen have no say in it.
Right.
It doesn't go to them for a final approval.
No.
We are, okay.
Right. Quite frankly, in relatively rare circumstances, there have been cases where the Board of Aldermen has appealed the decision of the Board of Adjustment because they disagree with it. There are a small, maybe a handful of cases in North Carolina where that's happened. It's very, very unusual. Usually it's the applicant, one who is opposed to the application, who would appeal.
And when they appeal, that would just go to court at that moment?
Superior Court.
Okay.
Yeah. So what happens is, once the order is signed, it's filed with the clerk, which, maybe with the zoning administrator or maybe with the town clerk, depending on local practice.
Okay.
But once it's filed, it has to be served, mailed to the applicant, and mailed to anyone else who had standing to participate. And then they have 30 days within which to file a notice of appeal or a petition for writ of certiorari with the court. That's legal speak. That it's language we use as lawyers so that no one else can understand us, again, to ensure that we have work to do.
Okay.
But it's a writ of certiorari is filed with the court, which basically means that the court will ask for the record of your proceedings to be brought before it, and then the attorneys argue about whether you were right or wrong.
Okay.
So would we be called to go to that, or would just?
There's no testimony in Superior Court
That was my
on
next
appeal.
question. I'm glad someone asked it and I didn't have to.
I mean, because that would go on
Because
behalf of us.
In the
You
case
can
of
what I signed up for right now.
in the case of appeals from the Board of Adjustment from quasi-judicial decisions, the Superior Court sits like a court of appeals, okay? And the Court of Appeals doesn't hear testimony either. The court is then making its decision based on the record that was generated in front of
Okay.
you. So there's no new testimony. They look at minutes, transcripts, if there are transcripts. They have a chance to look at all the exhibits that were entered into the record and make a decision, and of course, look at the ordinance, and then make a decision about whether a decision was by the record. Your decision has to be supported by substantial, competent evidence in the record. That's the legal standard for review of a Board of Adjustment quasi-judicial decision. Rendering a decision, res judicata, another one of those Latin phrases that lawyers love to use because we like to confuse people, but it just means that the matter has already been decided, so it can't be relitigated again. And that's the end of the presentation, formal presentation. I'm happy to talk anything that I confused you about, anything that you want to talk a little bit more about. Just say the word.
So, you will either be here or have someone from your firm here.
Yeah, TC Morphus is probably going to be here because I have to be in another jurisdiction on April 25th, where we've got a huge issue going on.
Okay.
So who are you representing? Or who is he going to represent? Us?
He's just here for us.
TC will be here to represent you.
Okay, cool. That's what I was, okay.
Just, TC, he's practiced for 25 years. I mean, he knows what he's doing. He represents boards all over the place, too.
So he is going to make sure that you do it correctly,
Good.
and that he is going to, because this is a lot, I mean, to not have done it before. Yeah. And so he'll just make sure that your procedures are correct, and then he'll also be here if you need someone to write them.
Okay.
I mean, I know this fire hose kind of a little bit. I mean, there's a.
It's the first time it's happened since I've been here, but that, it's not been like 2 years, so everything is new in Landis.
Yeah, and TC, he will help you if there are questions about hearsay, admissibility of evidence, all that kind of stuff.
Okay.
He will sit there and help you all make the calls. So
So what do you do if so many people come that can't fit in the room?
well,
Well,
I'm just saying, because the one I went to, there was like 400 people
Mhm.
at it.
Well, that's something to think about, you know, whether, if you think there may be,
But there's not gonna be any here. There's gonna be no opposition. Right, that's what we're just gonna go with. We're, oh
well,
gosh.
I'm trying to
I'm
read
scared.
Diane's eyes with
I
that.
know, like, we're
Um,
about to get, I don't know, it's like we're about to.
I mean, I think that's where we had determined standing before the
Yeah.
meeting started, right?
well, you want to make sure the people who have standing in particular make it in the room.
Okay.
You know, if people have to stand outside, you know, provided there's some way that they can hear what's going on, maybe.
I mean, it'd be live streamed, wouldn't it?
It will be live streamed, and we do have the option before, when we thought we were gonna have a lot of folks, we would set up the fire bay. When then folks says it was their turn to come in.
Yeah.
would come in and speak.
Yeah, that's the
Because
way
it's
it's,
attached right here, we could put up a screen so that it can still be seen in there, and that way they're still participating, it's just not in this specific.
right, right. And I've seen it done that way in jurisdictions before where overflow crowds, there's a space to put the overflow, and that works.
And then, like, can Sally from the beauty shop come and just observe? Because
Yes.
she wants to know what's going on.
Yep.
Okay, I'm just asking.
Yeah, because it is an open hearing.
Absolutely. Yep.
It's a real person.
Yeah, while it's not the public hearing in the sense of a town Board of Aldermen legislative hearing, it's a different kind of hearing. The public, the town's business needs to be done in public.
Okay.
And so to that extent, it's a public hearing.
I'm trying to prepare myself for the worst. That's why I'm asking
Yeah.
some of these, like,
Yeah. So, you know, fire away with questions. I've done these hearings, you know, hundreds of times. So to me, I probably forget how intimidating it can be
You've
for
been
you
very
guys.
impressive.
Yeah,
Like,
you've
I
been
mean,
great.
You've been great, yeah.
So
I
I just want
appreciate
to,
it.
Yeah.
you know, if you have questions that you have discomfort about,
So I think for me, being a new chair and everything as well, I would like, you know, things,
Mhm.
if that makes sense.
Well-
That's not a book I need to read between now and then or anything.
we can, if you want us to, prepare little scripts for,
Oh,
Some of these
please.
like phrases, that would be good.
well, for example, some of the opening comments about how the process will work, and writing out the oath, things like that. We can do
Yeah,
that.
I would love that if that's possible.
staff member that opens Amber?
Amber will be here, as your clerk.
So
I
she
will
will,
also be here, but I won't be here in, like, I'll be here, but I will probably, unless I'm needed, I won't be
so
participating.
she will be the one that will open, as you were saying, that we would have a staff employee open the.
No,
No,
Ryan will.
Right.
Well, you mean to make the presentation?
Yes, make the presentation.
Well, again, I don't know what the local practice is
Yeah.
here, but frequently, at the very beginning, at the very opening of the public hearing, once you open the hearing, the first person to speak may be a staff member who generally presents a summary of what the application is about. For example, this is application 22-01 for a special use permit. The applicant is XYZ Corporation. The property is located at wherever it is. It's 57 acres and it's zoned R2. And the applicant is asking for a special use permit to do whatever it is they want to do. And we're here tonight for the public hearing on the special use permit application, and I'll now turn it over to the applicant to present their case. I mean,
We will have the appropriate person here.
Okay.
and you know, those,
Could the guy that's coming do that?
He's representing
He's
us, not
us,
the
not the
staff.
staff, okay.
Yeah.
yeah, usually, you know, that in different jurisdictions, depending on how much staff you have, sometimes there's a staff report. Like the hearing I was at last night, there was a 3-page staff report. And the planner the staff report was part of the record. The planner kind of summarized what the staff report said. You know, I think it was 5 or 6 minutes. And those were the first comments made during the public hearing. And then from there, it was turned over to the applicant to present their case. And, they took as much time as it was necessary for them to present their application. And then it was turned over to the opposition, so to speak.
So the staff, situations has already made a decision. I mean, like, let's say,
Well-
for example, that, your situation where the staff has already decided if it meets what they think, whether it meets a special use or not. So could they still be the one who reads that thing at the beginning?
Sure. Well, if it's a special use permit application, and I don't even know what it's for at this point. Wait until we open up those packages.
Christmas, I'm terrified.
I mean, for example, with a special use permit, typically in my experience with the special use permit, what the staff report describes what the application is for, and says that the staff may say, we have determined that the application is complete, that the use requested is allowable in the district with a special use permit, and it appears that they have met the standards for the district. And then that's all they say, because from there on, the applicant has the burden of proving the 4 factors.
Okay.
I mean, that's typically, in some jurisdictions, staff make recommendations to the Board of Adjustment. I don't think that's a good idea.
No, that doesn't happen here.
Good.
I was thinking more about, we've had situations where the planning board itself was presented with a special use, right? I mean, think about what Lennar is a
Well, that's a condition.
conditional.
No. Yeah.
Yeah.
So it was a
So that,
zone with condition. It was an
Yeah.
MU.
so that was decided by the planning board,
Mm-hmm.
and then a recommendation was made to the Board of Aldermen. But if the applicant didn't like that, then they could come back and appeal to the Board of Adjustment, right? Or not?
From a Board of Aldermen decision? Typically, the appeal from a Board of Aldermen decision would be to court, typically.
Okay, all right. Okay,
So if that happened and we denied it, they come back for an appeal then?
If you deny this application in 2 weeks, then the appeal from that denial is to Superior Court.
Okay, yeah.
Yeah. Because the way it works is an appeal from a staff decision under the LDO is to you. And then the appeal from your decision would be to Superior Court.
Okay, gotcha.
An appeal if a Board of Aldermen decision, if it's a legislative decision, well, it doesn't make a difference, even if it's a quasi-judicial, would be to Superior Court.
Any other questions from anyone?
thank you again for coming.
Yes, thank
Oh,
you.
You're very, very, very welcome. It was a pleasure to meet you. I hope I haven't confused you too much, or I hope I've confused you just enough.
No, there you go.
So if I wake up
You
to,
make sure that you're gonna be needed in 2 weeks.
yeah,
It all sounds much more complicated maybe than it really is when you sit through it. This might be seems like it's overwhelming, but kind of look through the PowerPoint a little bit, and it's pretty thorough, maybe more thorough than it needed to be for tonight, but it makes sense, and at least to me, and after working 35 years
No,
doing
I
it,
thought it was great.
Yeah.
And we don't have anybody that sits on this board that has done this before.
Mhm.
So that makes it even more, it's not just like Ryan's done. We don't have anybody that's sat through this before. And so that makes it really important for this training to happen.
how much?
I think the time is great.
How many applications, like a year, does the Board of Adjustment typically review here?
I've been on here for a year and this is one.
Okay.
Appeal.
I've
One appeal.
been here at the town for 2.5 years and I've never known one.
So
How long have you been on board?
Right before you.
Oh,
I thought he was the old time. I thought you were here for
so
like
the
years.
the infrequency of
A week before you.
okay.
the infrequency of the process makes it much more daunting to you, and it's really not as bad as or as complicated as it seems. Especially, remember the rules of thumb. Use common sense. If it doesn't feel right, if the hair on the back of your neck goes up, there's probably something that's a little bit screwy going on, and you ought to think about it. Listen to your lawyer. I mean, is always a good rule of thumb. But also, just if you listen to the testimony and apply the standards, you're going to be fine.
Okay. So let's say I sleep tonight, wake up, and I have a question about the operations of the process. I was about to say trial, and I knew that was the wrong word. Who do I then reach out to?
I brought business cards.
Can I reach out to you to ask that question? Again, not like, hey, this is the case, here's what we're doing, but hey,
If
I just want to make sure I.
He's your attorney.
if Diana's
Okay.
okay with it, I mean,
Okay.
I brought cards.
Yes,
because I
please.
And Mr.
And TC?
Morphus, they are our representatives.
Yes.
Okay, cool.
So,
I just want to make sure I can
Never
ask
had an
somebody,
attorney.
and I'm not flooding Diane with 25 emails in one day. I'll flood you with.
there you go. That's okay.
Well, and with representation here, you're not standing up there by yourself. You're
Right.
going to be, in fact, we may get a chair right there beside you, just for that
Yeah.
person.
Can I get an earpiece?
I'll
What was I
you
saying?
can sit right here.
So
Not
when you
proud.
were responding to that, it made me feel
It was,
like
no, I'm
you
participating
see
in that.
more towns and cities have lots of appeals.
Yeah.
You were surprised that this was our first.
Be the one that opens the flood.
Well, a little bit,
Okay.
but generally, and this is not hard and fast rule. The smaller the town, the less frequently you have these kinds of things come before you.
And growth is really just taking,
Mm-hmm.
but that's probably going to happen.
Sure, as the population spreads out from Concord and Charlotte and stuff like that, you're probably gonna experience more appeals and more special use permit applications, and as a result, these processes will become more commonplace, and then less scary because of more commonplace.
So if I'm the applicant applying for an appeal, can I appeal something that was decided 4 years ago?
No.
How long ago?
There's 30 days to appeal from a decision that, say, the zoning administrator makes. There's 30 days to appeal from your decision to Superior Court.
So this is something that's happened within the past 30 days.
You will be familiar with it. I mean, you should.
Again, I know
Okay.
nothing about it.
No, I'm just making sure. This is making me feel a little bit better. That's why I'm
What
asking.
I'm saying is you shouldn't have something come before you that you, unless you're brand new, that you haven't been a part of.
Okay. Okay.
Because if it's 30 days, unless you haven't been here longer than 30 days.
Oh, I wouldn't hear that.
Huh?
You haven't denied
Three
anything
choices.
since I've been here.
In 30 days, yeah.
Okay.
What's happened?
Okay. Okay. I know I'm feeling better now. I was terrified it was something from like 5 years ago in the back of my head. That's why. Oh, okay.
Now, if it were a special use permit application, I mean, that's not an appeal, that's a direct application to you guys. But,
Kind of got an idea.
Okay.
I'm so clueless because I wasn't here.
All right. Cool. I don't have any more questions.
all right.
I should have started with that question, so I would have went into this process a little bit, feeling a little bit better.
So we need to adjourn.
Yes. So, did I make a motion? No, I can just adjourn.
Yep.
You can just adjourn.
Do it.
Thank you so much. I would like to adjourn the training for the Board of Adjustments. Appreciate the training you did and appreciate your time and distance you came.
Thank you, thank you. I was happy to be here.